Good evening. In a few months from now, the draft of the Digital India Act, meant to be the most significant piece of IT legislation in our country, will be out for discussion. It's an act which will have a profound impact on every aspect of how citizens use IT tech or online services, and it's now clear that social media companies like Twitter and Facebook will be accountable for whatever is posted on their site. Those were some of the hints dropped by the government. But first, what is the legislation about, and what about the immunity that a Facebook or a Twitter have had in terms of what people post online? If that immunity goes away, how will they ensure that they are accountable? Will that be difficult to ensure that all hate goes away? Lots of issues. We're going to be looking at all of that. But first, what the new law, the draft of that, is actually looking to achieve.
In simple terms, social media, cloud computing, metaverse, blockchain, cryptocurrency, deepfakes and doxing all get covered under the new Act, which will replace the decades-old Information Technology Act 2000. While we don't yet know the full contours of the Act, we do have an idea what it proposes on one of the most debated issues: safe harbor for social media intermediaries. The basic question is this: should online platforms like Twitter or Facebook continue to have zero liability for what users post on their platform? This is a crucial issue in India and around the world, a debate that looks at who is responsible for taking down harmful content online while still ensuring that the best practices of free speech are protected. And from what we know so far, the government is clear. There will be no free pass to social media companies. Safe harbor, as it exists now, cannot be an excuse to let harmful posts remain. Under the new Digital India Act, each intermediary category will be subject to new regulations with a heavy focus on fact-checking to prevent misinformation or misuse of data. Additionally, these platforms will now be held accountable for any content violations or cybercrimes that occur on their websites. But then there's the key question: what precisely defines harmful content and what should be taken down? A larger debate that is bound to pit free speech activists versus the government. But the government appears clear: the weaponization of misinformation will not be allowed, and that extends to a few other areas as well. Deepfakes, for example. Using AI called deep learning can put words in people's mouths. You can star in your own favorite movie and a lot more. So the key issue in this case is then impersonating someone and violating their privacy. Doxing, meanwhile, a form of online harassment which publicly reveals someone's personal details like their real name, their address, their job details, etc. It extends to phishing too, which, as you know, are online attacks that are used to steal user data, including login credentials and credit card numbers.
All right, so that's a look at some of the key issues over there. The entire issue of immunity for Twitter and Facebook, that's something that exists now. In other words, Twitter and Facebook, other social media platforms, are not responsible for what you and I actually post over there. But that is proven to be problematic as far as the government is concerned, because let's face it, there is a lot of hate out there. But what makes this entire debate so very important is because it pits the need to ensure that social media, for example, is safe, that there is not evil information out there, dangerous information out there, misinformation out there, versus the need to ensure that the freedom of online speech is always protected. So it is a difficult battle, and the government is pushing back with this particular digital law, which it's still in the process of discussing very closely. N.S. Nabinai, founder of the Cyber Saathi Foundation, joins us, as does Apar Gupta, and Jiten Jain. Will be joined by the Supreme Court advocate Gopal Jain as well in a little while from now. Mr. Napinai, let me come to you first. Just from a technology standpoint, is it possible for a Facebook or a Twitter to get rid of all hate, of all information which is deemed to be inappropriate, just on the basis of algorithms?
Vishnu, good evening. See, when you're posing a question in this manner, it appears as if the response is supposed to be 0-1. Nothing in life, and definitely not in tech, do you get a 0-1 answer. So when you were also giving the introductory statement, and I wanted to clarify that, and that answers your question also in a way, you mentioned about how, and this was what they called it, okay, when the genesis of the safe harbor comes from Section 230 of the Communications Decency Act, and it was referred to as the 26-word sweetheart deal. Big tech knows it best that sweetheart deals always have an expiry date. But when you're talking about the protection or the immunity that is given to intermediaries disappearing, it's not like a proposed law is going to do away with the safe harbor completely. You have to understand that the law would be nuanced and it would deal with the situation in terms of whether the information emanates from a social media platform or that which is shared on the platform by third parties. And even with respect to what is shared by third parties, in the introductory part, the critical word actually came up, which is about whether it is going to be removed or not. So the minute you talk about removal, it is something we are speaking about which is after the effect, right? So nobody is holding social media responsible for what is being uploaded, but they do have a responsibility when it comes to what is being removed. So to answer your question, one of the earliest attempts in terms of what we call as active filtration as opposed to passive filtration, which is for removal of known criminal content, the India Supreme Court led the fray in Prajwala case, where they talked about the possible use of artificial intelligence to be able to identify and not remove, but quarantine. Because we are fully conscious of the fact that you have to balance free speech with the rights of victims also. So victim rights have to get a fillip here.
No, I understand that, but I think the question which I'm asking is that is technology enough?
It was about child sexual abuse content and violent videos against women. So when we talked about the use of technology,
are you able to hear me?
Everything can be filtered, but an attempt at responsible...
Ma'am, are you able to hear me? I think we've lost the line with her. We'll just come back. Are you able to hear me? No. What I'm trying to ask is, given the volume of, whether it's tweets or information online, is it at all technically possible to monitor everything? Because the onus falls on...
I'm a lawyer.
The onus
I'm a lawyer, not a technical person. But as a lay person, I would assume that none of us can really talk about filtering everything, and nobody is asking anybody to do that either.
No. Nobody is asking anybody to do all of that. But obviously, those things which are objectionable...
What is feasible and what is enforceable.
Right.
It is neither illogical nor can it be so.
Right. Jiten Jain, would you like to actually take that? Because I haven't got an answer to this very basic question. Can you actually remove everything, after it's been posted? Obviously, that's when the process of accountability starts. Because a lot of people would suggest that this is going to be a huge fight between the government and whether it's Twitter, Facebook or any other social media platform in terms of physically being able to remove all of that.
No, Vishnu, that is not even required, and that would not be even required by the law. See, understand what is safe harbor. Under Section 79, and in US also, as Napinai pointed out in Communication Decency Act, and in India, in Section 79, there is a safe harbor provision under IT rules where these social media companies or intermediaries have been given an exemption and certain immunities from the liability from any prosecution because of a third-party content being posted on them. So, but this exemption or this immunity is not absolute. There is a condition as long as they comply with the law of the land, which is they follow the government directions, they comply with the government legislations, the parliamentary legislations, and they comply with the government directives. Now, for example, what has been happening? See, this safe harbor is a 40-year-old construct of 1980s. Even in India, it is now 20-year-old. That time, social media in this current form was not even there. And the first example of this debate came, I think, almost 15 years ago when Bazi CEO was jailed because a student posted an, profane video or MMS of a girl on Bazi and the CEO was jailed. And then finally he had to fight a court battle and he came out. And then his point was, look, somebody posted something on my auction website. I was not even aware of what it is. And that is the reason to avoid such arrest and harassment, this safe harbor was introduced. But now look what has happened. This protection was available only to intermediaries. Who are intermediaries? Who do not manipulate, play, edit or moderate the content. They are just a via media like your telecom service provider, like your internet service provider. But social media companies, initially they said that, look, we are only an open book. Somebody comes and posts something. How are we responsible? Which was fair. But today they moderate the content. they censor the accounts, they block the accounts, they take money to manipulate algorithms, what will be shown first. They even restrict the free speech. They suspend accounts as a policy. And now to an extent, they're also trying to get into sovereign functions where they're trying to interpret laws, refuse to comply with government orders. And by the way, this is not only in India. This has happened in Australia also, where Google and Facebook gave front page advertisements in Australian media accusing Australian Parliament and Australian government of running a misinformation campaign. They suspended government accounts. Twitter was suspended in Nigeria for election.
So I understand that. So my question, Jitin, is how is there greater accountability now, most likely,
now what will happen?
from social media platforms?
Yeah, now what will happen? See, like in Twitter case, when government asked them to suspend 20,000 odd, this ISPR accounts, Twitter refused to comply with that.
Right, exactly.
Now, as soon as something unlawful, as per the law of the land, we can debate about it, is brought to their notice, and then they refuse to comply, then only the safe harbor provision will go.
Right.
See, once you are aware of the illegality, and then you are refusing to comply, then you are responsible.
Right.
Not for, as you are saying that everything what is illegal, they have to remove it, is humanly not possible. But once it is brought to their notice by any user, customer, government, and if they don't comply, then these protections have to go.
So they don't have to they have to proactively try and get rid of whatever it is that is deemed to be incorrect. And secondly, if something is brought to their notice, perhaps by the government, and they choose not to listen to the government, then they could get in trouble and lose that safe harbor status. That's what you're saying.
Vishnu, last point. See, just look at for the general public. India doesn't have a data protection law. India doesn't have a privacy act. India has been struggling to deal with these companies when accusations of Cambridge Analytica election interference came against Facebook. India struggled to take on Twitter when they refused to comply, because the only option available to government was to block the platform itself, and which was not possible because it was unproportional. Now with this new Digital India bill, there might be proportional punishments, like it has happened in Europe. There is a Digital Security Act where there might be some financial penalties if they don't comply with the government directives, if they don't comply with the law. There might be a graded punishment mechanism. Australia, South Korea, Europe has already done away with the safe harbor in so many ways by bringing their own laws. So India is not the first country. And the last point I want to make, you see, Vishnu, this is a comprehensive overhaul of 20-year-old IT Act. This is going to deal with cybersecurity, data privacy, data protection, hacking.
All of it. Yes, absolutely.
So the definitions of intermediaries will also change. Now, you and me have to ask a question. Is Amazon Prime intermediary?
No, so they're quite clear about it. AI, e-commerce, digital media, over-the-top platforms, search engines, TSPs, gaming, ad tech, SSMIs, etc. They'll all come under the definition of intermediaries. That's what the government is proposing at that stage.
Just one line. If you moderate the content or if you interfere with the content, you're no more intermediary. If you do not interfere with the content, you have the protections available. That should be the simple law.
So, Apar, the bottom line at one level is on what defines something which is wrong. I mean, obviously, there's the law of the land, pornography is illegal, crimes against women, children, etc., wrong. Hate is something which is wrong. But when this gets misused by the government, as has been the case or allegedly, to try and push for content to be removed which may be of a political nature, that becomes problematic. Is there anything in this law proposed, right, which would prevent that from happening, or is it going to be the same thing?
Thank you, Vishnu, for having me here today. And it's good to be on this debate because I think it also signals that something which we have been actually discussing for so many years, those problems with the IT Act, there's an opportunity now to solve it. But is there enough seriousness from the government to do this, and whether it's being done in a way which is clearly headed towards any kind of resolution? I think it's important for us to consider. And here I'd like to point out that, for instance, this news program which we are doing today is on the basis of stories which have been carried from a consultation done in Bangalore yesterday. This consultation was done by the Minister of the Electronics and IT. And prior to that consultation, there was no clear way for the public to participate. There was no approach paper. There was no clear outline of the intent of the Digital India Bill or the Digital India Act. It's not a law, so let's call it a bill.
Right.
Secondly, the presentation which was given is a PDF presentation document, which is of 29 pages and does have certain comments such as on safe harbor, on doxing, etc. And safe harbor is also put in a question mark, but it's almost as I've taught certain courses, it seems like a student's presentation which does not have clear explanation. And this becomes important. And this is not, I'm saying this in jest. I think this is important because we are dealing to resolve problems which have lingered for close to 2 decades. Secondly, just much more closely, whether we can look towards a resolution. We've been promised a Digital India Bill and Act actually first in April 2022. So it's almost been 1 year. All we have is the PDF presentation. And this is the first mention of the Digital India Act on any official government portal. I say this with full responsibility after checking the PIB releases as well as all government websites. And why I'm saying this is that at present, you have the IT rules which were made on February 25th, 2021, which seek to regulate social media companies, which have had further amendments, and you have had now government committees which are directly empowered to overview the content moderation decisions of each social media platform, which essentially means if I complain and I say I don't like this tweet, me Apar Gupta as a private person, and I say I don't like this tweet, that platform refuses to take it down, I can actually appeal it eventually to the government and a government body. And all of these IT rules are right now under challenge before the Supreme Court. Parts of them have been stayed by 3 high courts. I'm saying all of these things because we today have a tremendous opportunity to move ahead and to resolve these difficulties which we have been facing for some time. And the path forward, I would like to discuss it further. And I'm sure other panelists will have something to add on this as well.
No, so what is the path forward in regulating content?
I think the path forward is already to some extent known by the Ministry of Electronics and IT. I think the problem set and as well as what was read out earlier is too large. It cannot be dealt by one singular enactment because even the IT Act essentially emerged from model law to regulate e-commerce and then some additions are made to it. The problem set is so large, it needs a Digital Competition Act, it needs a Digital Markets Act, because these companies are gatekeepers. We need to look at the economic models. We need a Digital Services Act, how data will be shared. And in addition to that, we need to update the IT Act. I would say that you need large-scale, comprehensive legal reform because the world today is very, very different. So the nature of the objects of a singular enactment and to bundle everything together has the very potential of giving something of too many cooks cooking one broth. It may not serve anybody's
All right,
palate.
I get that point. Jiten, you had a point to make, and then I'll go back to Ms. Napinai. Yeah.
Vishnu, I think this is the point I was also trying to make. I agree with Apar that for last 5 years, we have brought so many amendments to IT rules, a lot of new legislations that we have been doing this piecemeal legislative efforts to do a sort of firefighting to deal with emerging problems. And that is why all those efforts are failing because they were challenged as, not having a backing of law. Some people challenged them that they were not fair or proportional. But now this comprehensive long due overhaul of entire IT Act, I think will take care of all these things. And I am sure, it's just only a draft. There will be long consultations. But remember one thing, these companies today have a revenue which is more than the collective GDP of 25 countries. These companies are trying to act as sovereign. These companies are today refusing to comply with sovereign laws, and 5 people sitting in a boardroom have capability to influence the election in a democracy. So do you want to treat them as intermediaries? And that too in a case where they are publishing paid news articles, they are hosting movies, they are getting into interviews, they are running recruitment platforms, they are running search engine, emails, and they're also sharing this data with their third party companies which have absolutely no accountability. Like for example, WhatsApp is now sharing data with Facebook. Is WhatsApp an intermediary? Facebook is sharing data with Instagram. So tomorrow Facebook is an intermediary and Instagram is not, what do you do? So that is why I think anybody who plays or who does anything with your data, anything, even moderation, restriction or anything, or even deletion or, addition, should not have any protection under intermediary. And even if those who don't do it and have, and once it is brought to their notice, then if they don't comply, these protections should not be available. And one simple example for everyone in the country to ask. Tomorrow, if a law enforcement authority asks, a telecom company to put the phone of a terrorist on surveillance, and for some reason that telecom company says that no, he's a freedom fighter, we will not do it. Can they do it? Will the protections be available to them? Tomorrow, if a ISP refuses to block a terrorist website, should those protections be available? No. I think it is not humanly possible to report illegal on the platform. But once it is brought to your notice that something illegal or unlawful is there or harmful is there on your platform, then if you don't remove, then those protections cannot be made available.
Ms. Napinai, the other way of looking at it, of course, is that intermediaries have already, and I'm looking at that 9-page document that Apar was talking about, intermediaries have already started acting upon harmful content. YouTube, 58.2 lakh channels, 30% of which are from India, have been removed, etc., etc. Meta, 327 crore content has been acted upon. Is there a sense that more still needs to be done to protect, users, or do you believe that the government is coming down with this potentially with a very heavy hand?
Indeed, there are already actions that intermediaries have initiated, not just because of the laws that are from India, but also from other global territories. For instance, after a lot of the attacks that have happened, and I don't want to go into each of these lists, if you look it up, you will see them. You will see that a lot of European jurisdictions have also called upon various big tech to act on fake news and hate speech, and particularly grooming for terrorism. So when you look at the way AI has been utilized on various platforms, you will see that these are initiatives that are happening from across the world, not just because of what India is doing. Secondly, Vishnu, you have to keep in mind that the very jurisdiction which gave us this safe harbor provision, which is USA, is also contemplating a change in its approach to intermediary protection. Sure. You have two cases which are pending before the US Supreme Court. One is Gonzalez versus Google, and another is against Twitter versus Thumbnail. And in these two cases, you're going to see critical outcomes which are going to impact the way forward. The way I look at it is this: I don't think anybody is going to question the right of intermediaries, and particularly here I think we should use the word significant social media intermediaries and not Correct. Intermediaries as a generic term. I don't think anyone is going to question their right to exemption or safe harbor when it comes to third-party content. If you look at Section 230 itself, if you look at the restrictions under Section 79, which Jitin pointed out too, you will see that clearly the law lays down a ring fencing by saying you're protected with respect to information, and I'd like to emphasize that word information, posted by third parties. And as all the speakers have pointed out, and whilst we may be saying it in different words, ultimately it all leads to the same path, I would say, for the way forward.
Okay.
Which is that, one, there will be some protection, but the protection cannot be a blanket free pass. You will have to exercise responsibility. You will have to use technology also as a preventive measure.
Sure.
You will be answerable to multiple jurisdictions because you are amenable to multiple jurisdictions.
Apar, one final question. Sure, ma'am, I get that. I just running short on time. I wanted to go to Apar. This also tries to deal with a lot of other contemporary threats: phishing, doxing, the use of deep fakes. And a lot of these technologies are still in their relative infancy. So, do you believe that what the minister is trying to do by, saying that this is something this needs to be a huge bill now because it has to be looking at the future and where technologies are going, do you believe that to that end it's an important step?
I think so, Vishnu. If you try to criminalize conduct which you don't really understand, you may end up with situations such as Section 66A. Now, let's remember the intent behind Section 66A was also positive at the time when it was made. But when you make something vague, when you are trying to regulate, let's say, spam emails which cause annoyance, but you make a legal provision which is really broad, which is what may occur, that may result in that legal provision, as well intentioned as it is, being used by local police thanas or cyber crime cells to register offenses against people on the internet. Why I think is that also a possibility is because some of the things which are termed as harms may not immediately be offenses. For instance, in one of the earlier press interactions, and this is a reported press interaction, mighty officials have stated that something called as gaslighting needs to be also criminalized. Now, gaslighting as a term I know is used by millennials as well as Gen Z in day-to-day conversations, and that is also a form of sometimes social disrepute, social injury, but it is sometimes also an offense. Our own understanding about stepping and making legal provisions over things which we do not understand and making it a criminal offense results sometimes in empowering a local thana or a local cop to basically
And there have been countless examples
of
of this, Apar. That's what this is all about. There have been so many occasions when local police have started, threatening. There've been arrests over social media posts. Journalists have been threatened. Political leaders, activists, so many artists have been targeted. The worry is that this might still continue. So, protecting
Vishnu,
everybody is important.
I was a lawyer in Section 66A case, and I saw the section being applied for a person who printed somebody's photo on a birthday cake, and sent it to their house. For a person who protested against the police, for a person who alleged corruption against a politician, and the kind of offenses which were alleged under it was so different under the fact situations. I think there's a real risk. So I think we need more deliberation on the objectives by itself of the Digital India Act, because it's trying to do a lot of things at the same time.
Vishnu,
Jitin, you have exactly 30 seconds.
Yeah, I think
Give
while
him
we
15,
debate
please,
Indian
and
laws,
give me 15.
while we debate Indian laws, we should also look at the conduct of these companies in other geographies. Look at the Twitter files and the internal emails Elon Musk has published about Twitter-owned employees and chief of safety. Now look at their connivance and collaboration with US intelligence agencies in US elections.
All right, I get the point. I mean, these aren't innocent companies. And Ms. Napinai, last 15 seconds to you.
Yes,
very innocent,
very
I must
quickly.
say.
So, as Apar pointed out, all the phrases that are being used, gaslighting, etc., are colloquialisms. A law cannot be based on colloquialisms.
Sure.
At the same time, what matters, and this is very critical from a victim perspective, Vishnu, which is, please don't look at a heading of a section to decide what it is criminalizing. It is the provision that matters.
All right.
And therefore, if you're looking at a law, it's not about having titles which will say gaslighting or catfishing. It's about what is the criminality which is going to become an offense.
Exactly, and I think Apar would agree with that. It is the nature of the criminality which shouldn't be abused. Right? Look, let's leave it over there, and I promise you we'll be discussing a lot more of this. Great discussion. Thanks very much for being with us. Thank you very much indeed.